Hi everyone, welcome to Impact Academy. So today let us continue with the Indian polity. Okay, Indian polity. Last time we have seen till 10 questions. Let us continue from the 11th question. Okay. So which one of the following statements best describes the significance of the preamble of the institution of the Indian Constitution? Now preamble we have seen so many times, right? Let us once again briefly look at the preamble. Okay, because frequently questions are asked on the preamble and a couple of things if we keep repeating it will be better for us. So the preamble you have to remember sovereign, socialist, secular, democratic and republic, and out of this secular, socialist and integrity are added later, okay, in the 42nd Constitutional Amendment Act of 1976. That is, in 1975 we had the emergency, right? So remember all that. So initially only sovereign and democratic republic was there. That is one frequent asked question, and these are frequently asked: justice, liberty, equality, and fraternity. And what kind of justice? Social, economic, political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity. Fraternity is basically assuring the dignity of the individual and the unity and integrity of the nation. So all these things are frequently asked. And one more thing is, see, adopt. This is one thing. Okay, when was the constitution adopted? It was adopted on 26th November 1949. Okay, basically the preamble was adopted. But if you say when did the constitution come into force, then obviously that will become 26 Jan 1950. The basically our Republic Day. So all these are very important. These differences and everything is very important. Now let us look at the question. It's a very standard question. Which of the following statements best describes the significance of the preamble of the Constitution? Preamble is a symbolic introduction and holds no legal importance. So this is in a way true that it does not hold any legal importance, but it is not just symbolic. So the preamble serves as a guiding light reflecting the aspirations and ideals of the constitution makers. So this is a very standard statement. So I think outright you can go for this statement. So that is the option. Answer is B. Okay, that is what I mean. Standardly, when you read Lakshmi Polity or any, that's the reason you need to keep reading these textbooks so that it will be easy for you to identify the statements. So it serves as a guiding light and it reflects the aspirations and ideals of the constitution. So this is the right option. And it is not legally enforceable. So this is wrong. It is not a legal document. Okay, it is just a guiding light. So Article 13. Okay, let us briefly look at Article 13. So if you look at the fundamental rights are also very important. And the fundamental rights will start from Article 12 and it will go up to 35. Okay. So all these articles you have to remember each and every article. So what does Article 13? Basically, Article 12 defines okay what is the state and all those things. And Article 13 deals with laws inconsistent with or in derogation of the fundamental rights. So just keep that in mind. Now let us see the question. Which of the following are covered by the term law as enshrined in Article 13 of the Indian Constitution? So, if you look at in general, if you are, what is law? What is the state? Okay, state is obviously your executive or your legislature, basically that which controls, which makes the laws and which enacts these laws and gives the rules and regulations. And the law is ordinances issued by the president of the governor. Yes, it does have the effect of a law. Okay, and statutory instruments like orders and regulations, which is also true. These orders and regulations they can be considered as part of law. State legislation definitely is a law. Okay, states are equally powerful in most of the especially when it comes to law and order, agriculture, several issues. State have an upper hand compared to the union. Next, customs having the force of law. So this one you have to understand. Even this is true. Okay, usually you may think this may not be, but actually this is also if you read the Lakshmikant Polity regularly, you even look. Frequently you come across this. Okay, customs having the force of law. So all are correct options. So it is D. Okay. So ordinances issued by the president or the governor, they are covered as laws under Article 13. Statutory instruments like orders and regulations, yes. State legislation is also covered under the term law, and even customs having the force of law. So this is where you might get confused and go for option C, but it is actually option D. So which of the following added the duty to provide opportunities for education to children between the age of 6 and 14 years to the Constitution of India? So, when we are talking about education, let us look at a couple of things. First and foremost thing is Article 45. Okay, Article 45, if you look at it, there is a provision for free and compulsory education for children. So, previously, this particular 45 article used to deal with the education of children. Later on, if you look at the Constitutional Amendment Acts, so let us look at the 86th Constitutional Amendment Act. Okay, so, okay, fine. So, 86th Constitutional Amendment Act of 2002 is very important. It made elementary education a fundamental right. How? By adding a newly added Article 21A. Remember, this is 21A. So, previously, Article 21 deals with life and liberty. Okay, it's a very important fundamental right. On top of that, Article 21A was added with 86th Amendment Act of 2002. Very, very important. This basically goes with this, what is education for all. Okay, there is this slogan that basically this act has been enacted for education for all. Okay, remember that that's also frequently given. And what it says, Article 21A, the state shall provide free and compulsory education to all children of the age 6 to 14 years in such manner as the state may determine. So this is very important. Remember 6 to 14 years. Okay, and it has changed the subject matter of Article 55. Sorry, 45. So previously 45 used to deal with education. Now it added a new article 21A, and there it gives 6 to 14 years compulsory. Means basically the state will provide. That's why if you go to any government school, it is free of cost. And for Article 45, it changed the subject matter that the state shall endeavor to provide early childhood care up to age of 6 years. So 6 to 14 is covered in 21A. Up to 6 is the responsibility of the state. Okay, but this is in directive principles, so it is not legally enforceable. You can't go to court saying that the government is not providing any preschool facility, etc. So from 6 to 14 years it is the fundamental right, so the government will have to, you can go to the court. On top of that, added a new fundamental duty under Article 51A. So Article 51A fundamental duties, okay, Swaran Singh Committee, 42nd Amendment Act, all those things we have seen, right? All those are very important. And what does this 51A say? It shall be the duty of every citizen of India who is a parent or guardian to provide opportunities for education to his child or what, okay, between the age of 6 to 14. So basically, the state will provide free education, and as a parent, it is your duty to see that you avail that education. Okay, so there are three articles which deal with education: 21A, 45, and 51A. And all this because of, I mean, these things, what you can say, are 42nd Amendment Act of 1976. And this 21A and the change in Article 45 is because of 86th Amendment Act of 2002. Fine, this is a very standard question. Everybody knows this. So even you have to know it very clearly. So it is C. There is no confusion. 86th Constitutional Amendment Act of 2002. And 42, 44, I'm sure everyone knows, right? 42 is called as the mini constitution, 1976. And 44th Constitutional Amendment Act is to revert some of the changes that have been done here. Okay, especially regarding the quorum, regarding the number of years of the Lok Sabha, all those things, everyone is aware. So 92nd, just quickly look at what is 92nd, because it is there in one of the options. Let us also see what is 92nd. So 92nd Amendment Act is here. Included four more languages in the 8th schedule: Bodo, Dogri, Maithili, and Santali. With this, total number of languages became 22. So initially they were 16 and then they became 22. So 92nd Amendment Act is regarding languages in 8th schedule and it added Bodo, Dogri, Maitri and Santali. Just keep it in mind. And it is in 2003, 92nd Amendment Act. It is also an important act, but if you can remember, remember, otherwise it's fine. So, which of the following is a key difference between the Indian parliamentary system and the British parliamentary system? So, already we have seen that we have adopted this Indian parliament, I mean, the British parliamentary system. I mean, we have gone for the British parliamentary form of government rather than the American presidential form of government because this system of government provides for more responsibility than stability. That is also frequently asked question. So we want more responsibility than stability. So this provides for more responsibility. And the American system provides for more stability because the president is not responsible to the Senate. The Congress is responsible to the Senate. Anyway, so if you look at the options, India, the state head of the state is hereditary, which is true. The head of the state, sorry, in India, the head of the state is not hereditary. Okay, in Britain, the head of the state is elected, which is completely wrong. Head of the state is monarch. This is also wrong. There is no monarch here. In India, the head of the state is elected, which is correct. We are talking about the president. While in Britain, the head of the state, the queen, the king, is hereditary. So this is that. Okay, the head of state is appointed by prime minister, which is wrong. Okay, so C is the obvious answer. So C is the answer. Simple question. Now let us look at the last question for today. The institution of the Speaker of Lok Sabha is introduced by which of the following acts of the colonial period? So, if you look at Government of India Act of 1919, okay, we have frequently looked at it. Let us quickly look again. So, 1909 Morley-Minto reforms, Government of India Act 1919, Montage transport reforms we have already seen. It provides for a responsible government. Office of the High Commissioner of India was created. Indian legislature became bicameral for the first time. Remember this. Okay, bicameral means you have both this Lok Sabha and Rajya Sabha. At the state level, you have assembly and council, right? That is bicameralism. And that was introduced in 1919, very important. Communal representation means immediately you have to remember 1909. And Lord Minto is called as the father of communal electorate. That is one thing. Separate electorate for Muslim, 1909. And that was extended. So frequently questions are asked in which act it was introduced. Then it is 1909. And in 1919, it has been extended to six Christian Anglo-Indian Muslims. And the diarchy in provinces, okay. This again, I keep telling again and again. In 1919, they introduced diarchy in provinces, not the center. Then in 1935, they abolished the diarchy in provinces and they put provincial autonomy. And in center, diarchy is introduced. And what is diarchy? Diarchy is basically kind of a dual government where you have transferred subjects and reserved subjects. Okay, transferred subjects and reserved subjects. So all that is important. So, and devolution of legislative authority by center to provinces, separating central and provincial subjects. Fine. So, in this, there is nothing related to speaker. So, let us go to speaker. Let us see. So, if you look at the speaker, okay, the speaker, let us briefly look at the speaker. Article 93, very important. It provides for the election of both speaker and deputy speaker. So keep that in mind. Article 93. Speaker is the constitutional and ceremonial head of the house. Observe this, constitutional and also ceremonial head. Each house of parliament has its own presiding officer. So for the Lok Sabha, it is the speaker and there is a deputy speaker. And for the Rajya Sabha, it is the chairman and a deputy chairman. And this chairman is ex officio the vice president of India. Okay, observe that. Very important. And the institution of speaker and deputy speaker originated in India in 1921 under the provisions of the GOI Act of 1919. Basically, the Montagu Transport Reforms also have provisions regarding the speaker and it came into force in 1921. Very important, remember. And speaker and deputy speaker were at that time called president and deputy president. And in GOI 1935, the nomenclature was I mean, the president and deputy president were changed to speaker and deputy speaker respectively. Next, what is the criteria? The Constitution of India requires speaker should be a member of the House. Okay, he should be a member of the House. So he has to be an MP, or at the state level he has to be an MLA. And the voting, the speaker along with the deputy speaker is elected from among the Lok Sabha members by a simple majority of members present in voting. So usually it will be someone from the what you say, from the not from the opposition, from the party in power. And term is 5 years. Speaker holds the speaker holds office from the date of his or her election till immediately before the first meeting of the next Lok Sabha. That is for 5 years. The speaker, once elected, is eligible for re-election. Whenever the Lok Sabha is dissolved, the speaker does not vacate his office and continues till the newly elected Lok Sabha meets. So, if the Lok Sabha is dissolved, speaker does not vacate immediately. Once the next meeting takes place, see, till the first meeting of the next Lok Sabha takes place, then he will vacate the office. All these are important points. Interpret roles and powers of the speaker, interpretation, final interpretation of the constitution, provisions of the constitution, and rules of procedure and conduct of business of Lok Sabha and the parliamentary precedents within the house. So this is a very frequently asked question. These three things try to remember. He is the final interpretant of provisions of the Constitution of India. That is one thing. And the rules of procedure and conduct of business of Lok Sabha. This is also frequently asked. And parliamentary precedent. That means all the things that happened in the past. Just like Supreme Court rulings are also, I mean, officially the Supreme Court can refer to the previous Supreme Court ruling. Similarly, the Speaker can also look at what happened in the past. In matters regarding interpretations of these provisions, he or she often gives rulings which are respected by members and are binding in nature. So, whatever the Speaker says is binding in nature. Next important thing is joint sitting of both houses. So, the Speaker presides over the joint sitting of the two houses of the Parliament. Very, very important. And when is such a sitting summoned? It is summoned by the President to settle a deadlock between the two houses on a bill. Okay, if there is a deadlock and one house is passing, the other house is not passing, then the President summons a joint sitting, not the Speaker. All these are very, very minute but important points. When such a question is asked in the exam, this is where you can get confused. So have what you say, the fundamentals have to be clear. So it is the president who summons the joint sitting and the speaker presides over it. And he can adjourn the sitting, he can adjourn the house or suspend the meeting if there is no quorum. That is 1/10 of the total strength of the house. And he has a casting vote. That means if there is a deadlock, then he can vote in the last. Okay, in case of a tie, he can vote, and obviously that will decide the issue. And usually, whatever the party in power is favoring the cause, usually the speaker also votes to that particular issue. And such a vote is called casting vote, and it resolves the deadlock. Especially money bill, Article 110, very very important. Okay, Article 110, you have to keep it in mind. That regarding the money bill, the speaker's decision is final. If the speaker decides that it is a money bill, then it is a money bill, and he plays an important role in disqualifying the members. And disqualification is 52nd Amendment Act of 1985, which is the 10th schedule. Very, very important. And in 1992, Supreme Court ruled that decision of Speaker in this regard is subject to judicial review also. So, if any hasty decision is taken without a proper precedent, then the judiciary will intervene. And is also ex-official chairman of the Indian Parliamentary Group. Okay, and privileges. Okay, is the guardian of the rights and privileges of the House, committees, members, all those things. And if you look at the removal of the Speaker, Speaker remains in office during the life of the Lok Sabha, and these are the conditions under which he will vacate. That is, if he ceases to be a member of Lok Sabha. Suppose he gets convicted for something for more than 2 years and he loses his membership of the Lok Sabha, he is now no more an MP. Then he will not be a speaker. The speaker has to be a member of the parliament. I mean, if you are talking about the speaker at the parliament level, if he resigns by writing to the deputy speaker, or if he is removed by resolution passed by a majority of all the members of the Lok Sabha. So usually if you observe, the speaker is usually a person from the majority. So usually he will not be removed by a resolution. But if he is resolved, he is removed by a resolution. That means he has lost the confidence of the his own party. Anyway, these three are no, the cases, the conditions under which the speaker will vacate his office. And such a resolution can be taken only after giving 14 days advance notice. In such a when removal for speaker is under consideration, he may be present, but he will not preside over the meeting. He will be just sitting, but he will not preside over the meeting. So we have seen a very brief about speaker. Now, uh, the question is the institution of Speaker of Lok Sabha is introduced by which of the following act? We have seen it is Government of India Act of 1919. Okay, the Montagu Chelmsford reforms introduced the speaker. Okay, introduced the what is the office of the speaker, but it came to force in 1921. So remember that also. That is also very important. So let us look at five more questions in the next section. Thank you.